Good afternoon and welcome to the second module of the HIMT 104. We are going to cover Chapter 3 and 4. Chapter 3 is over the legal system in the United States and Chapter 4 is over legal proceedings. Let's discuss the U.S. legal system and the public versus private laws and how laws are classified. So laws are classified as public or private. In public law, that involves the federal, state, or local government and its relationship to individuals and business organizations. Criminal law, government is a party prosecuting an accused who's been charged with violating a criminal statute or criminally violating a regulation. And then in civil law, and remember these are all still under public law, civil law, regulatory activities for which non-compliance is a non-criminal act in nature. So let's look at private law, and these are the laws that concern rules and principles that define rights and duties among people and among private businesses. The government's not a party. We have several sources of laws, and first one would be the constitutional law. That's the body of law that deals with the amount and types of power and authority that our government is given. The U.S. Constitution has three branches: the legislative branch, which is Congress, the executive branch, which is the president, and the judicial branch, which is the Supreme Court and those courts. Statutory law, then, are the statutes that are enacted by a legislative body. So U.S. Code, or USC, is the compilation of all federal statutes. Administrative law is the executive branch that enforces those laws, and it's enacted by a legislative body through development of rules and regulations. And you will see that under the U.S. Code of Federal Regulations, or CFR. Common law, then, is the judicial or case law, and these are the decisions. These are based upon court resolutions of disputes. The outcomes vary from state to state and federal court system to federal court system. And stare decisis, let the decision stand, and precedent. So lower courts and court systems are bound to apply decisions of the higher courts in the same court system when determining the outcome of a case, if the fact pattern of the case in the higher court was similar to the current case. Conflicts of law occur when there's an inconsistency between laws of different states arising from legal action that involves more than one jurisdiction. So state versus state, federal versus state, and this is a supremacy clause. Let's go back and get a little more detail about some of this. Legislative branch actually enacts the laws in the form of statutes. Now, bicameral or two-chamber model consisting of the Senate and the House of Representatives. Then we have the executive branch, which enforces laws through creation and issuance of rules and regulations by the administrative agencies. For example, federal regulation of health care. So Health and Human Services oversees Medicare, Medicaid, Indian Health Services, and other entities. Another example would be state regulation of health care, and these are the numerous agencies that deal with disbursement of the Medicaid funds for mental health, public health, and etc. Now we have the judicial branch, which interprets the laws and adjudicates the disputes, creating common law. Federal and state course applies res judicata, or a matter already judged. Basically what that means is if it's already gone through, that's how they read the law itself. This is the reason why when you walk into a lawyer's office, you'll see two books. And literally one set of books is the word for word of the law. The second set of books is how it's been adjudicated. So separation of powers then limits the authority of each, inhibits any one branch from becoming autocratic. The state court system then has trial courts, which is the lowest tier, and it's the general jurisdiction. Here's more serious cases or civil cases dealing with larger sums. Limited jurisdiction, here's cases related to a specific subject matter or lesser severity crimes such as small claims, domestic relations, lord tenants. While the state appellate court, that's the middle tier, here appeals on final judgments of the state trial courts, and the Supreme Court, which is the highest tier for the state, here's the appeals from the appellate courts or from trial courts if there are no appellate courts. I rather liked this picture that we have on this slide because it gives us a little more detail of some of the things that we've been talking about. The federal court system actually has district courts, which are the trials located throughout the U.S. They have circuit courts. These are the appellate courts located throughout the United States, and they're nationally divided into geographic circuits. And then the U.S. Supreme Court, which is the final decision maker, and it's the petitions for writ of certiorari. Sorry, my Latin is horrible. Process by which a party submits a request for the Supreme Court to hear a case, and it only hears cases by granting the certiorari. So let's look at this picture. It says that the Supreme Court, of course we know what that is. The appellate courts, there's actually 12 regional circuit courts of appeals, 1 U.S. Circuit Court of Appeals for the Federal Circuit, and then we have trial courts, and they are, let's see, U.S. district courts, 94 judicial districts, and they're U.S. bankruptcy courts. Then we have U.S. Court of International Trade and the U.S. Court of Federal Claims. The federal courts and under other entities outside are military tribunal courts and appellate courts. And we also have the Court of Veterans Appeals, U.S. Tax Court, and federal administrative agencies and boards. This slide is actually a review of what we were just talking about. Supreme Court is the highest court in the federal system. It has 9 justices meeting in Washington, D.C. It appeals jurisdiction through certiorari process, limited original jurisdiction over some cases. Court of Appeals, immediate level in the federal system, 12 regional circuit courts, including the D.C. Circuit, and no original jurisdiction, strictly appellate. So the last is the district courts, and these are the lowest levels in the federal system. 94 judicial districts in 50 states and territories, no appellate jurisdiction, original jurisdiction over most cases. The federal court jurisdiction actually has a legal authority that a body possesses to make decisions. Federal courts can hear cases based upon 2 types of jurisdiction. Subject matter, which is the content or substantive area of case being brought, must actually be related to a federal law or the U.S. Constitution, while diversity jurisdiction, which parties are actually different states engaged in the lawsuit in federal court. So no plaintiff can be from the same state as any of the defendants, while the amount of controversy must be at least $75,000. The requirements of non-legal entities are voluntary and do not have legal authority, may nonetheless be powerful and influential. These might be accrediting bodies such as CAHIM from AHIMA, American Health Information Management Association. It might be the Joint Commission. It might be Healthcare Facilities Accreditation Program, the DNV GL Healthcare, Center for Improvement in Healthcare and Quality, which is a CIHQ. All of these actually have different requirements for them to be recognized. Let's talk a little bit about alternative dispute resolution. And this provides a less costly, less time-consuming mechanism outside the court system for resolving conflicts. So we use things such as mediation and arbitration. Arbitration is the dispute is submitted to and decided by a third party outside the court system, while mediation occurs by agreement of the party as facilitated by a mediator. And in the mediation part, they get together actually and talk it through with somebody sitting there making sure that it doesn't delve into just a screaming match. And this is the end of chapter 3.
Hi, I'm Craig, and this is Crash Course Government and Politics. As fans of our series know, here at Crash Course we believe in hierarchy. First at the top you got me, then there's John Green, then Stan, then Brandon, then Zulea, then a bunch of independent contractors. Wait, I'm an independent contractor. Well, I'm still at the top. Anyway, then the rest of it's turtles all the way down, except at the bottom. There's an eagle. Anyway, it's the strict adherence to hierarchy that makes CCHQ run like a well-oiled machine. The same can be said for the U.S. court system. As you probably remember, because you're a smart rememberer of things, the American court system is hierarchical, which means any discussion of it cries out for a visual representation. Thought bubble, like Drake, will start from the bottom. The trial courts have original jurisdiction. When you realize that there are 50 states, each with its own court system, it shouldn't be surprised that the vast majority of cases start out in state courts. Of course, most cases never get to court at all. The vast majority of disputes, criminal and civil, are settled outside of court. How's that for efficiency? On the federal side, the trial courts are the U.S. district courts. There are 94 of them with 663 judges, more or less. Sometimes in civil cases, a plaintiff, the person bringing the case, will have a choice about whether to bring that case in state or federal court. But you can only start in the district courts if your case meets certain important criteria. Almost all criminal cases start in state courts. So if you don't like the result in the trial court, and you have a reasonable claim that there was something procedurally wrong with the case or the way the law was applied, you can bring an appeal. Notice that if you start in state courts, you usually have more chances for appeal because most states have 2 levels of appellate courts, and the federal system has 1. Appeals courts can refuse to hear appeals, and if they do, you're done. One thing to remember, the loser can always try to appeal, even if that loser was the state that failed in its prosecution. Federal appeals courts are called circuit courts, and there are 12 of them, distributed regionally throughout the U.S. You might guess that the region where your case is heard matters, and you'd be right. Judges in the 9th Circuit, which includes California and Oregon, tend to be more liberal than judges in the 5th Circuit. Federal appeals are usually heard by panels of 3 judges, while trials in the district court are before a single judge. There are 4 scenarios where the federal courts have original jurisdiction, and in all cases, they must be brought in a district court. They are cases where the law at issue is a federal law, like a claim against Obamacare. Cases involving treaties, which are by definition federal laws. These are pretty rare and really interesting. Cases involving the U.S. Constitution, for example, a case concerning freedom of religion. And cases where the U.S. government is a party to the litigation. The other type of case that can go into federal court is one involving more than one state where there's more than $70,000 at issue. This makes sense because if the parties in dispute are in different states, they might not even agree where to have the trial, and federal judges are supposed to be more impartial than state judges. Thanks, Thought Bubble. So thoughtful. So bubbly. If you read the news and pay attention to legal cases, most of what you see are lower court decisions, at least until the spring when the Supreme Court starts handing down decisions. These are the ones that tend to make it into the history books and that you may have even heard of. But how does a case get to the Supreme Court, Craig? Well, I will answer that for you. That's my job. Most of the time, the Supreme Court has appellate jurisdiction. In fact, it's the final court of appeals. If you lose there, you've really lost. When the court hears a case, it's called judicial review. There are, however, circumstances when the Supreme Court has original jurisdiction and can act like a trial court. So it's a good thing that most of the justices are, in fact, lawyers, although there's no constitutional requirement that they need to be. The court has original jurisdiction in cases between the U.S. and a state, cases between 2 or more states, cases involving foreign ministers or ambassadors, and cases brought by citizens of one state against citizens of another state or against a foreign country. What do these cases have in common? The main thing is that you can't imagine there being a single state where they could happen. This is especially true in cases involving foreign officials. And then there are my favorite Supreme Court.
Let's talk about the legal proceedings then. Legal proceedings have 2 different laws that they have to deal with. Substantive law defines rights and obligations that arise between 2 or more parties. And the procedural laws are those that provides the court's rules to guide a lawsuit from beginning through completion, which is trial, settlement, and or dismissal. And the chapter that we're about to review focuses on the procedure rather than substantive. Let's talk a little bit about who the parties are to a lawsuit, and that could be the plaintiff, which is the person who initiates the lawsuit to enforce his or her rights or another's obligations. And there might be more than one. We have the defendant, and that's the individual or the organization that's the object of the lawsuit and against whom the lawsuit is brought. And again, there might be more than one. We also have a thing called a class action suit, and that's the lawsuit that's brought by a group of consumers against a large and generally more powerful entity for alleged wrongdoing. Now let's look at the proceedings themselves, and we're going to start with the pretrial. And when we have a pretrial, we actually start working on things like the litigation. And that's the litigation is actually the proceedings that accompany a lawsuit. We also have the pleadings, and these are the documents that are generated by the parties involved in a lawsuit. They include the complaints and the answers. Now, the clerk of the courts actually are the ones who maintain those documents. Commencing a lawsuit is when a complaint is filed, served on a defendant accompanied by the summons. Service of summons and complaint may be by a person, by mail, or by publication, and proof of service might be required. So basically, I'm sure some of you have heard about some of those complaints that have just been posted on in a newspaper or on a court website, and that's what we're talking about. So some of those are okay. Some actually require that we have a proof of that summons being served. Defendants respond with an answer, and the failure to respond to that summons can result in default judgments. Now, there are also additional actions that could be taken. The counterclaim is when the defendant claims against the plaintiff. A cross-claim is when one party files against another party on the same side of the litigation. And a joinder means that the defendant brings an outsider as a co-defendant. Let's talk a little bit about discovery. The definition of discovery is used to discover or obtain information held by other parties to assess strengths and weaknesses of each other's case. Now, there's a difference between discoverability and admissibility. The discoverability refers to limits on parties to discover pre-trial information, while admissibility refers to the evidence that will be allowed admission to court and is considered by the judge or the jury in making that final determination about a case. Okay, let's talk a little bit about legal proceedings. And let's look at some of the technical terminology here. For pretrial, we have litigation, which are the legal proceedings that accompany a lawsuit. The pleadings, then, are those documents that are generated by the parties involved in that lawsuit, and it includes the complaints and the answers and are maintained by the clerk of courts. Now, commencing a lawsuit is when the complaint is filed and served upon a defendant, accompanied by a summons. Now, the service of that summons and complaint may be in person, by mail, or by publication. Sometimes proof of service might be required. So we've all seen or heard of or read ourselves of some of those summonses or complaints being made, and we've seen them in the newspaper or on the court website. Sometimes we have to have a proof of service or a signature that says that you received it. Defendant responds via an answer, and then the failure to the answer results actually in a default judgment. Some of the additional actions that might occur would be counterclaim. That's when a defendant files against the plaintiff that has filed one against him. All right. Cross-claim then says that one party files a claim against another party that's on the same side of the litigation. So that might be the defendant claiming against another one of the defendants. Okay? Joinder then is when the defendant brings an outsider in as a co-defendant. We might also want to think about discovery versus admissibility. The discovery is actually used to discover or obtain information that's held by other parties, just to assess the strengths and weaknesses of the other party. And it also refers to limits on the parties to discover the pretrial information that's held by the other. So the admissibility then refers to that evidence that is allowed by either judge or jury to be admitted into the case. We have another legal proceeding that we have to think about, and that's the e-discovery. And according to the Federal Rules of Civil Procedure, which were amended to address preservation, collection, and production of increasing volumes of electronic stored information, or the ESI, addressing topics such as early court involvement in managing discovery of ESI, the scheduling, the scope of discovery, preservation of obligations, waiver of privilege, the format of the ESI production, and deriving interrogatory answers from ESI. Now, the considerations also include collection of information from source systems outside of those usually printed or viewed electronically. And some of those examples might be erased files, or it might be emails. Now, Electronic Discovery Reference Model, the EDRM, assists providers and vendors with steps to efficiently locate and prepare relevant ESI. There are other kinds of discovery as well, and those might be a deposition. And that's the form of proceeding under oath by which oral testimonies of individuals are obtained. Authentication establishes the genuineness of the records and therefore their reliability and truthfulness as evidence. Health information manager's testimony or written certification establishes that authentication of health records. Now, types of discovery might be interrogatories, which are written questions presented to parties of a lawsuit, and those answers are then provided in writing. Requests for production of documents are things such as health records or other tangible items like x-rays, lab tests. Physical or mental examinations of parties, and those are provided by an independent practitioner, which means they go away and outside of the organizations to find that physical or mental examiner. And then requests for admissions, and ask the opposing party to admit to certain basic facts to diminish time and money spent providing them. And in some of your past classes, we've talked about all of these things. Let's talk a little bit about subpoenas. And two forms of subpoenas. Subpoena ad testificandum seeks an individual's testimony, and subpoena duces tecum instructs the recipient to personally appear with documents in hand. Now, we talked a little bit about the subpoena, but let's talk a little bit about what you might find in that subpoena. And they vary state to state, but it should have the name of the court from which the subpoena was issued, name of the plaintiff and the defendant. It should have the assigned case docket, number, date, time, and place of requested appearance. Information commanded, in other words, whether they want just documents, they want testimony, or how they want this whole thing taken care of. The form in which the information, and that's including electronic information, is to be produced. Name of the issuing attorney. Name of the recipient being directed to respond, and signature or stamp of the authorized court or court official, or even the judge. And if those aren't on there, you need to step back and call the court and say, okay, or the authorizing the attorney, and ask them where these other pieces are. If they can't answer them, or if they just blow you off, step back, call the legal department, and that's where I would start. Now, if you have an objection to the subpoena, you can actually make a motion to quash, and that can only be based upon inadequate time for compliance. In other words, if they didn't give you enough time to pull all the documents together. Travel time beyond geographical limits of rule of procedure, and that means if it takes too much time to get there. So for example, let's say that Parkview was being requested for documents, but you had to take it to, I don't know, London. That's a little bit off. Request privileged information that's not subject to exception or waiver. Okay, so if they're asking for more information than what is actually required for the suggested suggested issue, then you need to go back, step back and say, okay, let's talk to the legal department. And it imposes an undue burden on the subject. And that means that it might literally cause too much damage to the entity that's being asked to do this stuff. So again, all of these things, when you have a question about this, just step back and say, okay, let's go talk to the lawyer. Understand that you don't want to do it just every time you get a subpoena. You don't want to just say, okay, I'm not doing this, let's go talk to the lawyer. Actually, that talking to the lawyer is the time that you want to every time you get a subpoena. And excuse me. So anytime you have a legal proceeding, you do want to go talk to the lawyer, and if you have any of these questions, talk to them as well. Let's talk a little bit about warrants and searches. There are judicial search warrants in which the judge has written an order authorizing law enforcement officers to search in a specific place and seize evidence. In healthcare, it's most likely done in fraud and abuse cases. Now, the Fourth Amendment of the Constitution protects against unreasonable searches and seizures. So think about what they're asking you to do and whether it's actually appropriate. Let's go talk about pretrial conferences, and these are the ones that are held periodically from filing a lawsuit throughout the discovery period to discuss how the case is going. It's also to discuss the upcoming trial and maybe even talk about potential settlement negotiations. And the people who participate are usually the parties, their attorneys, and the court or judge. Let's talk a little bit about who will be in that trial, and it would be, of course, the judge and the jury, whether it's a bench trial, which would still just be the judge, or a jury trial, and that's a jury of your peers, or the peers, or etc. Then you also will have the plaintiffs and the defendants. You'll have witnesses, whether they be lay or expert, and lay means non-expert. You will have the bailiff, the court reporter, and the clerk of court actually retains all the records. Okay, so the trial procedures, if the jury is weighed, then the judge is the one that hears the case, and the number of jurors actually depends upon whether it's the civil or a criminal case. And in the jury selection, which is voir dire, the attorneys can excuse potential jurors for cause, and peremptory challenges also occur, and that allows the juries to be excused for unstated but lawful reasons. Now, the opening statements, and that outlines the evidence, presentation of evidence by the plaintiffs, and then examinations by the defense, presentation of evidence by the defendant, and then, of course, cross-examination by the plaintiff. Now, there might be motions for directed verdict, and that may follow the presentation of evidence by each side. This is the request for the court to determine that the case is over at this point, and it's favorably to the requesting party, meaning it's judged favorably towards them. So we also will have closing arguments, jury instructions, deliberations, which means the jury will actually go in and make a decision, and then then the verdict, and then the damages. And the criminal has to be unanimous, while civil is just a majority established by state law. And no matter what happens, it has to be done with the burden of proof, and that's sufficiently proving or establishing a requisite degree of belief for each element of a case. And it usually belongs to the plaintiff. Now, it has to be beyond a reasonable doubt in criminal cases. It has to be clear. It has to be convincing evidence, and the preponderance of the evidence. So, particularly used for malpractice cases. Okay, after the trial's over, a couple things can happen. We can either appeal, which is, it can be appealed to the next court in the tiered system for a review of alleged legal errors at the lower court. The petitioner would be the party appealing the case, and the respondent would be the party whom the case is appealed. against whom the case is appealed. And then we have the collection of judgment. And in equity, the defendant is required to do or refrain from doing something. There's also money awards that require collection through either garnishment of wages, which is a percentage of wages set aside to pay the judgment, a writ of execution, which directs law enforcement to seize personal property to satisfy the debt, judgment lien, which encumbers the defendant's property to prevent the taking of money from its sale until judgment is owed to the plaintiff has been paid. And then medical malpractice insurance can cover a lot of what the monies are that are awarded by the court. And goodness gracious, it's the ending of this week's lecture. Thank you for listening. And this is the end of Chapter 4, Legal Proceedings. Thank you.